Welcome everyone to our 3PB Family Law Brunch. Today we have two topics for you. We have decision making in Schedule 1 claims and forgery and lies in divorce, some practical tips. Now, as you're listening, feel free to post any questions in the Q&A box, and we shall do our best to answer them all at the end of the two talks, or possibly afterwards if we can. And please rest assured you will get the slides after the talk, so don't stress over taking notes. And without much further ado, I'm very excited to present Louise Worton with her talk. Louise is a specialist, a financial remedies practitioner, and also undertakes property work and is the deputy head of the Property and Estates Group. She's a senior practitioner called in 2000 and has been ranked in both the Legal 500 and Chambers and Partners directories. So Louise, I'm handing over.
Thank you very much. Thank you, Antonida. Welcome, everybody. I'm going to share my slide deck now. Hopefully that's come up on your screens. Included within this pack, I've included not only the subject matter of today's talk, but I've left in some background information for you. Not everyone will be familiar with Schedule 1 claims in the same way that not everybody's practice extends out to doing Solata claims. So I've included for you what I hopefully are some useful background. So setting out, for example, what is a Schedule 1 claim? Schedule 1 of the Children Act 1989 is a claim for financial provision for children. That is going to be something that increasingly comes to the fore within our practice. The reason for that is that the majority of children are now officially, as of the last 2 years, born outside marriage as opposed to within marriage or civil partnerships. So the matrimonial wide-ranging jurisdiction not being available, people are going to have to increasingly fall upon Solata and Schedule 1s. Haven't quite caught up, though, the number of applications being made with the number of births. Query whether that's because people are less familiar, less knowledge that this is a route available to them. They were, for the last statistics I was able to access, only 104 Schedule 1 applications and 230 in 2022. As I say, bearing in mind that the number of children that are now born outside of marriage, that's something that I would hope that is going to see going up in the near future. So I've set out for you some useful places where you can find information. The Act itself is just 17 short paragraphs, so it's an easy Act to get your head around. There are the Useful Essentials Guide at the front of the Red Book and a procedural guide. The two key cases, if you want to start getting into this work, I've set out for you at the bottom there. REP, a decision of the Court of Appeal, is the seminal decision. The decision of Lord Justice Thorpe will take you through each and every one of the aspects that you'll want to be looking at to get yourself into this work, but even easier than that, one of the nice user-friendly guides that Mr. Justice Peel is creating is set out in Y versus Z 2024 decision, and that's a very user-friendly guide to Schedule 1 applications. He sets out the law. You're going to start to see that, I suspect, cut and paste into the decisions that you receive by other judges, just setting out the framework for you. So anybody that's less familiar with this work, I've set out within these notes, and you will be receiving these, as Antonida said, a copy of the background information, who may apply. The overlap with Solata, you're going to oftentimes see these run together, particularly, as I said, with the increase of unmarried couples having to resolve their family finances. Applications can be made against children. What sort of orders has the court got the power to make within a Schedule 1 application? Well, it has the power to make periodical payments, lump sums, settlements of property, and transfers of property. But in reality, the types of orders that you're going to be receiving, the vast majority of them are going to be lump sum orders. Periodical payments really only arise when we're falling outside the child maintenance regime. What we're looking at providing housing for children during their minority, during their dependency, and any incidental costs. They can extend to providing for older children cars and education, whether that's private education or tertiary education. I've set out there for you some of the special features. I'd remind you, if you don't already know, that the Schedule 1 jurisdiction is needs only. What we aren't looking at within Schedule 1 claims are sharing or compensation. Those just don't feature within a Schedule 1 application, and it's important to always bear that in mind. Legal costs. You can make an application by way of interim periodical payments if you're falling outside the CMS regime. So if you've got one where you've got a very wealthy father and a less able mother, you can make an application for legal fees. Section 22ZA doesn't strictly apply, but we apply the same principles, and Judge Mostyn set that out for us in Rubin and Rubin. So the same type of exercise to get yourself a fighting fund. So turning now to the substance of today's talk, what are the decision-making factors within a Schedule 1 application? Well, Schedule 1 jurisdiction, it is highly discretionary. No magic computer, I'm afraid, that we can put these figures and information into that's going to give us the exact right answer. Paragraph 1 tells us that on an application made by a parent, guardian or special guardian, or any person named in a child arrangements order as a person with whom a child is to live, the court may make one of the more of the orders mentioned in subparagraph 2. So the exercise involves the court striking a balance between various factors. So those of you that are financial remedies practitioners already will recognise the exercise. It's very similar to applying the Section 25 factors. So we'll be looking at what factors the court has to take into account. I'm afraid, however, it's not simply as easy as just looking at a list. There are a list that are set out in paragraph 4 of Schedule 1. However, there are also a number of judicially developed criteria that we're also going to have to look at. So I've set those out here in some detail for you. So, although it's not expressly listed as a factor, welfare is a key consideration. It's described by Lord Justice Thorpe in that seminal decision of Repeat as being a constant influence on the discretionary outcome. So even though it's not listed there, it's going to be your beacon. Always sense checking any decision, any submission against that constant influence. Any order that the court goes on to make must be for the benefit of the child. Again, that's not expressly referenced within paragraph 4. You might think it is, but it's not. However, each of the subsections in paragraph 1, 2 does go on to reference for the benefit of the child. Now, what does that mean for the benefit of the child? The benefit of the child can be direct or indirect. And a key area of consideration is whether that benefits the parent. I have, for ease of reference, referred to it as being the mother in these slides. I, of course, recognise it could just as equally be the father. But for ease of reference, I've looked at it from the perspective of being the mother. That is sadly the way a lot of the cases are as well. So we need to look at whether or not it is a benefit to the child. It doesn't matter that it's an indirect benefit to the parent. So a roof over the child's head will also provide a roof over the parent's head, or indeed half siblings or other children. And the court's striking a balance. Can be of benefit indirectly to somebody else, But the court needs to be vigilant, we're told, to guard against unreasonable claims being made on the child's behalf with the disguised element of providing for the mother's benefit rather than for the child. And I've put the reference there from Miss Justice Hale as she then was. So what sort of things might we be looking at here? Well, there's some brilliant examples. Gym membership. Gym memberships for mothers, but don't allow the children to go to the gym, or we're talking about a babe in arms. There can be maintenance of a tennis court when a child is far too young to be able to play. There's a nice entertaining judgment from his own Judge Hess recently that talks about the prolific footballing skills, or the lack of a 1-year-old when mother was making a claim for very expensive artificial grass. Claims as to nightclub membership. Apparently, if you don't register in these most exclusive of places when you're 2 years old, you might not get in when you're 18. So was the allegation of the mother, who was asking for a nightclub membership to cover herself and the child in future. Benefit of the child, it is given a wide construction, so the court will look at the particular circumstances. And I've set out there a couple of examples for you of what perhaps might be a little bit outside the box thinking that you might not conventionally have expected. So in Ries, for example, a fund to enable the mother to travel to Sudan to see the child was for the benefit of the child. So an award was made in the case that enables the mother to be able to go back and forth to see the child who was at that time residing in Sudan. MT versus T, 2007 case, looked at the question of legal costs. Yes, a fighting fund for the applicant was appropriate, as that person was bringing the claim as a quasi-representative. Child maintenance awards can also extend beyond the direct expenses of the children. So a wide construction. Does that amount to a carer's allowance? Well, that's taken a recent development with the introduction of what's called a HEXA, a Household Expenditure Child Support Award. Just what we needed, some more acronyms. Decision of Mr. Justice Mostyn in Collado Fuchs, sorry. And I've set out there the full quote for you because it's quite useful. A child maintenance award can extend beyond the direct expenses of the children. It can additionally meet the expenses of the mother's household to the extent that the mother cannot cover or contribute to those expenses. And Judge Mostyn came up with the delightful HEXA as a term of phrase. The essential principle is that it is permissible to support the child by supporting the mother. But a HEXA cannot meet those expenses of the mother, which are directly personal to her and have no reference to her role as the care of the child. Collado Fuchs was indeed the nightclub case, so an example was a subscription to a nightclub. However, the award can meet the expenses of the mother, which are personal to her, provided they are connected to her role as a carer. Some examples being the provision of a car and designer clothing. Judge Mostyn was clear to say that it can be quite difficult to draw the bright line between what is and what isn't for the benefit of the child, but it's something that should be looked on a case-by-case basis. One shouldn't have the child of a multimillionaire having to have somebody look after him that is in perhaps a charity shop or very low-value clothing, driving around in a beat-up old car. Those are things that are appropriate to look at. You might, by way of analogy, want to think about it in terms of what one might do for a nanny. You could employ a nanny to look after the child. If mother's going to fulfill that role instead, why should she not have the same benefits that would have been provided to a nanny? So returning to the judicially developed factors, a key consideration is the standard of living. That's not listed anywhere in paragraph 4, I'm afraid, but it is a highly material factor. That's how PLJ described it in Y versus Z, and that's why I really do recommend that case as a useful source of going through and identifying the key factors. I'm afraid it arises particularly in big money cases. Schedule 1, like a wide variety of financial remedies law cases, I'm afraid the principles do derive from cases where people are very wealthy, and it's important to try and keep a sense of reality sometimes when reading these cases. Quite different, perhaps, certainly from my own lifestyle, and I suspect the lifestyle of many people listening in today. There are two leading cases on the question of standard of living, Al Maktoum and Colorado Fuchs. So Al Maktoum, a prime example of the case that's not quite in the run of the mill of the people that come in through the door. This was the separation of the ruler of Dubai, who was separating from the sister of the King of Jordan. Believe it or not, they had to fall onto the Schedule 1 jurisdiction for various reasons. As might be anticipated, a credible amount of wealth in the father's family. And Justice Moore came up with this phrase about a lifestyle not entirely out of kilter. So the children should be able to have a lifestyle that is not entirely out of kilter with that enjoyed by them in Dubai and that enjoyed by the father and his family. So the standard of living is important to bear in mind. How is it that the parent who is the respondent is living their life? What are the resources they have access to? However, there's an important thing to bear in mind, is that not every Schedule 1 application is going to derive from a situation where the parents have been in a loving long-term relationship. Sometimes it will be as a result of a one-night stand. In Colorado Fuchs, there had been a 4-year on and off sexual relationship that came to an end shortly after the pregnancy was discovered. So what Mr. Justice Mostyn reminds us is that the standard of living before the breakdown of relationship should not, however, be allowed to dominate the picture, as there will be many children, particularly dealt with under the Schedule 1, who will not have experienced a standard of living within a functioning relationship, either because the liaison between the parties were very, very brief, or because the child was born after the relationship had come to an end. So a very wealthy parent is not able to simply walk away from their obligations on the basis, well, we didn't have a standard of living before the child was born. Schedule 1 decision making, it takes a broad approach, but the court ordinarily needs to determine the claims in a certain sequence. They will start off with what is going to happen with regards to a property, then move on to any lump sum that is necessary, and then move on, if appropriate, to child maintenance. Repeat tells us that the starting point is the home. We've got to look at the value, the size, and the location of that home in order to then understand what is going to flow from that. So reference there to REA, the nature of the child's home environment provides the obvious baseline from which to consider commensurate levels of maintenance and is as good as any other. So we've got to start somewhere, and where we start is where is this child going to live? The court is entitled to paint with a broad brush. We're told that specifically in Re P, that exercising this discretion, at least in big money cases, involves essentially a broad brush assessment to be taken by family judges with much expertise and experience in the specialist field of ancillary relief. Of course, when you start to get down into the middle or smaller asset cases, that brush is necessarily going to be less broad. But in the same way that when we do matrimonial finance, and while we have a number of questions in cross-examination, it doesn't come down to whether or not it is reasonable for the wife to be having Sky TV, whether it's reasonable for husband to be spending X amount on gambling or not. The court is looking at the bigger picture. Conduct. Conduct isn't listed under paragraph 4. It is not one of the specific factors the court takes into account. However, we do have reference to all the circumstances of the case, and therefore the really most egregious, the worst of all conduct, will be taken into account appropriately by the court. A couple of examples for you there. Owen P, Mr. Justice Baker, as he then was, found it impossible to ignore that the father had been convicted of inciting the mother's murder, not just to one person, but to multiple people. The mother was then left with an incredibly restricted life, extremely traumatically affected by the events. As Justice Baker said, that was something he couldn't ignore. Interesting case for you. Second reference there, TK and LK. That's a decision of Nicholas Allen KC, sitting as a Deputy High Court judge. The mother committed a criminal offence against the child. This led to a long custodial sentence. The child was left with PTSD. The father was left, had to leave his employment due to the stress of dealing with everything. Unusually, this was actually a Schedule 1 application after the parties had undertaken a divorce. However, the mother came into an inheritance, some £350,000, and father brought a Schedule 1 application. Effectively, the decision of Mr. Allen Casey was that should be divided in two, with half of those proceeds being divided as a housing fund for the child. I would just reiterate, and it's covered by the earlier slides, that one of the things that we're looking at in Schedule 1 applications is not necessarily money being provided outright in the long term. It's often to provide a housing fund that will revert at a later date to the respondent. We do, however, ignore that there is a potential for reduction of support at 18. A different REP this time tells us that it shouldn't be a relevant factor that the court takes into account, that when the respondent is no longer legally obliged to pay, that he or she might stop. That's not a factor to be taken into account. The court should not generally attach weight to the risk that the father will reduce or withdraw the support when the child comes of age or ceases education, thereby obliging the child to adapt to a lower lifestyle at that time. That lifestyle adjustment takes place at the age of 18 or when support ceases. It doesn't need to kick in when the child is only 5 or 6. Just highlight to you another important thing to bear in mind. Justice Hale, as she then was in J versus C, tells us that there is a public policy consideration, that there is a need to reduce or eliminate support from public funds. It's not a good enough defence for the respondent to say, well, the state will provide, either in terms of housing or in terms of income. So, we've covered the judicially developed criteria. Let's turn now to paragraph 4.1 itself. As I indicated earlier, it does expressly refer to all the circumstances including. So all the circumstances requires you to look at everything, and are there any magnetic components there? Well, there can be. An example often cited is MT and OT, in where Mr. Justice Charles held that the cultural factor, which was described in that case as the Nigerian connection, was a relevant factor. So why was the mother and the child were in the UK, and that those all should be taken into account as part of the circumstances of the case. Paragraph 4.1 reads, in a manner that is very familiar to FR practitioners. It's very similar to the Section 25 criteria. So what are the income, earning capacity, property and other financial resources in the foreseeable future? And that's going to be of the parent or of the applicant. The applicant has a slightly broader definition than just parent. Disclosure is going to be extremely relevant. I'd point out the millionaire's defence. As I indicated, a number of these cases involve individuals who are very wealthy. In REP, the father described himself as fabulously wealthy, and that he was able to meet any order the court might impose. The court therefore didn't require detailed disclosure in that case, a broad overview that made the court satisfied that it could indeed make such order as it saw fit. What about the income assets of the applicant? Well, an applicant of limited means is not required to use those means for the benefit of the child. That's F versus G. All the resources of the resident parent don't need to be applied exclusively to bringing up the child. They also have their own obligations, and that doesn't displace the obligation on the other party. Again, a familiar criteria: financial needs, obligations, and responsibilities. So looking at the broad picture of the parties. What are the financial needs of the child? So expect a list to be set out. I'd remind you, though, that there is limited jurisdiction in respect of periodical payments, child maintenance. Most cases are going to fall within the CMS regime. Schedule 1 only becomes applicable when we fall outside that. CMS applies up to, I think the current income cap, it hasn't changed recently, it's £156,000 a year gross. When you get beyond 156, the court generally applies the same regime as it would to up until at least 650,000. That's what the cases tell us. If you go beyond 650,000, the court can then do its own exercise. So the phraseology is we're looking at those in that bracket that are affluent to the fabulously rich. So needs of a child, expect a schedule like you would have a schedule of needs in an ancillary relief case. What are the income, earning capacity, property, and other financial resources in the foreseeable future of the child? A relevant factor is the physical or mental disability of the child. Schedule 1 applications can be used to provide specialist education, private education, and that rolls into factor F, the manner in which the child was being or expected to be educated or trained. So think about those scenarios where the father has been providing or oftentimes grandparents providing the funds to attend private schools, even up to the more exclusive end, boarding schools. Should that simply be taken away because the parents separate? A Schedule 1 application could be forthcoming in there, taking into account how the child was being educated or expected to be. What was the name down at birth for your Eton and for your Harrow type schools? So what are we looking at overall? Well, ultimately, the sense check, the outcome that we're looking for is something that is fair, just and reasonable, taking into account all the circumstances. That is the same repeat that I've been referring to throughout this topic. However, that is the judgment of Mr. Justice Bodie. That's the type of sanity check that we need to be doing overall. So it is a similar regime to the Matrimonial Causes Act, but not the same, and not the same in a number of key features. It'll be still similar to a practitioner when you're going through that exercise, thinking about what are the magnetic factors that pull the pendulum in one direction or the other, but it is a jurisdiction of itself. I hope that's been interesting and useful for you. We're now going to move across to hear Antonida's talk. Antonida's talking to you about forgeries and lies in divorce. Imagine that, forgeries and lies, people not quite telling the truth. Imagine that might be. Antonida's practice covers family, property, and court of protection. She has a particular interest in cases that straddle those areas. She was called in 2015 and is therefore a very experienced junior. I'm delighted to say that she was my former pupil, which probably gives her background as to why we go for these interest in these niche cases that overlap between the two areas. Thank you very much, everybody. I'll hand you over to Antonida.
Thank you very much, Louise. That was a really interesting and useful talk for myself to have a reminder as well. I'm just going to share the screen. There we go. Hopefully this all works smoothly. So my talk is rather more in the practical sort of direction. There's not going to be very much law, and what law there will be, I won't cover in a lot of detail, but I've set out in the slides points that might help you in terms of researching or checking them later. Obviously, forgery and lies, I'm sure all of you have come across some degree of this in your cases, but perhaps in my experience, it comes up more often than one might expect. And I can never tell if that's because I look for it more or if because somehow I've got typecast into doing these, which is no bad thing at all. And of course, I've been inspired to do this topic because of a number of very memorable cases where we managed to successfully prove that the other side, for some reason, invariably the wife has forged documents. Actually, no, one of the cases had both of them forging documents, in particular bank statements. But I wanted to share some of the experiences, hopefully, to help others to be maybe braver in challenging some of these things. There were a couple of questions I will answer at the end, but please feel free to ask more. And also, if you have your own experiences you want to share as you go through listening to it, I'd be very interested to hear them, and because that will help me to learn as well. So the first, now, how do I move this slide as the question? Oh, there we go. The first question really is, what are we looking for? And I'm sure there's many more forms than this, but the most familiar, perhaps you will recognize as in witness statements of people saying one thing and then statements don't match, or you can compare their consistency with other evidence. And we send our trustee counsel to cross-examine the witnesses, and if the suspicions were correct, the court will not believe the witness. It's nice and straightforward. Forged bank statements, obviously, I'll come back onto because that's my sort of major point that I want to focus on. Forged agreements, again, often turn on the authenticity of a signature. There are sham trusts where there's perhaps an overlap with third-party interests, but some of them more legitimate than others. You can find letters from people or organizations have been faked. For example, a friend supporting one side's case. P45s, employment tenancy contracts, emails purporting to be from someone else, which is easier to do than you'd expect, although I've yet to convince a judge about this point, but then it hasn't come up as a main point yet. So a key thing to think about, which will be important in showing to the court and convincing them to listen to you when you're trying to prove some form of fraud or lies, is to find the motive and show why it is that whoever it is lying. Obviously, they might be concealing assets that are not properly disclosed. That's an obvious point. I had in one of my cases, I'll call it case one, the wife was hiding universal credit payments so that she could receive maintenance pending suit and then hire capitalized spousal maintenance and generally look like she's poor and living in poverty while the husband's living well off, which wasn't quite the case. And in case two, I had a different wife also hiding universal credit payments on her bank statements. But in this case, because she was committing benefit fraud, and her argument, her explanation was she was afraid that the husband would stop her receiving benefits. And quite rightly, the judge pointed out the only way he could stop her doing it is if she wasn't entitled to receive them in the first place. But in the same case, case two, the husband was trying to improve his case by getting his cousin to start a sham tolata claim against the best of the properties. And as a result, found himself exposed by the court to HMRC for not having paid quite a lot of tax over many years. So it's key to work out why someone is lying and what they're going to get out of it. And that can be difficult to do when someone's lying very poorly, i.e. they're not really doing very well in concealing the issues with their statements and other documents, because the judges may well say, well, I don't believe that Mrs. So-and-so is such a Machiavellian scheming mastermind. I don't see why she'd do it. And of course, she wasn't particularly good as a mastermind, but she was lying, which we did prove in the end. So how do you spot forged bank statements? Starting there for a start. And this is, perhaps I'm slightly strange in this, but this is my favorite part of a financial remedies case. The point where I sit down with my cup of coffee and the bundle of bank statements and start going through and working out what people spend their lives doing. And there's no better way to spot forgeries and inconsistencies than through that slightly forensic analysis of the documents and the bank statements right from the start. It may be tedious work, but actually there's no substitute for this process. And once you've got your eye trained to be looking out for these things, it becomes quite quick. So things to look out for. For a start, almost always bank statements should be provided in PDF format. If you're seeing them, sometimes they come in what's called CSV and they will come up as Excel documents. Better to ask for a proper PDF to be provided, but that's not in itself a guarantee that it's forged. If they're in Word, then you definitely know there's something suspicious going on because no bank provides them in Word. Fonts. Again, small thing, and you do really have to be very pedantic to spot these things. But if it's Times New Roman or Arial or Calibri, you will know them, or probably Helvetica if you're on an Apple Mac. It's very unlikely to be the actual font that the bank is using on their official bank statements. They will have their own font. Particularly suspicious if you're seeing half the bank statements disclosed in one font, and then the other half bank statements suddenly with some phrases being in Times New Roman underlined with a classic Microsoft Word red wiggly line as if there's a typo. It definitely gives you reason for suspicion. Again, looking at the time periods, if the bank statements were always from the 12th to the 11th of the month, and then suddenly they start being provided for the 1st to the 31st of the month, that's not something the bank just changes just like that. Old bank logos or the statement template that they use. Obviously, we all have our own bank statements, and sometimes people provide statements from the same bank. You can know if that is not the way that bank statement looks. Particularly useful if the party providing that bank statement at one stage worked for that bank and may have had access to an old template. Totals not adding up. That's the classic one, and for some reason people always get this wrong. When they're changing in these statements, and of course you could get a PDF bank statement from this bank and then convert it into Microsoft Word, which is what in case 2 the wife did, and then make amendments on it. But for some reason, people just don't check that the totals add up afterwards. At the end of every page, there will be sums, and you can check if they make sense or not. Missing pages, again, you've got to check where they are, at least ask. Inconsistent transaction descriptions. If you've got a few lines saying Tesco Redhill, and then suddenly it says Redhill Tesco, that is not likely to be a coincidence unless Tesco has just suddenly changed their, it's not going to happen very often. And if Tesco is doing it and Asda's doing it and BP and Shell are also doing it, you can see there's something off here. Similarly, transaction types. If the transaction is, for example, BGC, which is usually the description for salary payments that people receive, but the description is something like train tickets, I don't know, London Marylebone Station, that can't be right. If it says cash withdrawal, but actually says transfer to my account, that can't be right. And so on and so forth. So have a look and learn what those codes mean. Amounts disappearing between accounts. And that's quite an obvious one. If you've got a set of bank statements, you should be able to trace every transaction. Now, you might not need in every case to be checking and tracing every single transfer that someone makes between their own accounts. But if you've got other inconsistencies, it might be worth checking a few to see if you spot amounts disappearing. And suddenly, before you know it, there might be a hidden bank account that hasn't been disclosed, or it might have been transferred to someone completely different, or money is being withdrawn and going God knows where. And remember with that, in fact, to check the full account numbers and to know the full account numbers that the parties have, because the case one that I had, the wife had two account numbers that had the same last three digits. And for a very long time, we were looking at these bank statements, not realizing that, in fact, they are for two different accounts, and that, in fact, one of them hadn't been disclosed. And similarly, don't trust the names necessarily on a summary sheet. It varies, of course, from between banks how they present their specific statements, but it's Lloyd's particularly that will often have a summary sheet that will list all the accounts and then give the detailed statements. Now, it's usually accurate on the detailed statements, but on the summary sheet, the customer is able to change the description of what they call that account. So they might change that name to be, for example, the name of their child, even though it's not actually their child's money. Or they might change that to be a completely different name, a friend or someone else entirely, their mother, their father, and then say, oh, well, no, actually, that was an amount I owed to them. Last but not least, sometimes you will get a letter or a statement, and always be suspicious when things are redacted for no apparent reason. We had one letter in case one, which was purported to be a bank statement of a friend who was looking after, for some reason, some £30,000 of the wife's money that she'd been transferring in little bits. And the address was redacted. But you could see from the shape of the redacted box that it couldn't possibly have contained the actual address of the friend, which we knew, and looked much more like the address of the wife. Obviously, none of these things guarantee that someone's lying or forging their statements, but they are definitely sufficient grounds to start some more investigation. Now, other than to find the actual forgery of the bank statements themselves, bank statements can be a treasure trove for other very interesting information that can come in useful, particularly in cross-examination later. Again, obviously, dissipation of assets. I always like to create a spreadsheet that effectively lists, as soon as I start getting suspicious of too many transactions going out to a particular person or coming in from a particular person, just list all of those and provide a little table in the position statement, which will show quite how much money, because sometimes it adds up to a lot of money that's being either dissipated or someone's actually earning a lot more than they're saying. Or again, you might find undisclosed accounts. You might find money being transferred into the ether. It says to be to the same person, but it's not in fact visible anywhere else. Again, you might find some specific spending that can be really useful to the case. And again, that's very fact specific. I had one case where the wife was saying that she was struggling to feed the children because the husband wasn't paying child maintenance. And this was actually an attempted Schedule 1 periodical payments case, which didn't go anywhere. And yet, when you looked at her bank statements, there were several days when she was spending upwards of £100 in Selfridges and eating out almost every other day. So all it takes, you find a couple of these examples and you say them to the judge, look, we don't have to go through everything, but just this one day, for example, we've got her going to a spa, we've got her going to a hairdresser, getting her makeup done, doing a shopping to some amount, and going out to eat several times. Is this a woman who is in fact living in poverty? the answer will be invariably no. The total assets, again, if you've got a sort of case where the totality of the assets might be important, like if someone's hiding or committing benefit fraud, sometimes people don't check that limit of £16,000 that is the maximum assets they're allowed to have isn't there across their different accounts. So each account will show a smaller amount, but if you actually add them up at the same date, they might have more than that £16,000. So that can be a useful point sometimes. And finally, locations. If a party, for example, is claiming that they live in one place, but actually we think they live in another place, or they say they're not working, but every day, Monday to Friday, they're appearing in a particular place, or they say they're not in a new relationship, but you can see them in a locality where you think their new partner lives, the location data in bank statements can be really useful to that. And again, because it can be so specific, it can get the judge's attention in a way that they will remember and that will affect them on, get them to listen on an emotional level, because it's the sort of thing where, for example, we had in case 2 where both the husband and the wife were lying left, right, and centre. There was an issue about jewellery. The wife said the husband had retained it. The husband said the wife took it. If you've dealt with jewellery, as I'm sure most of you have in divorce cases, it's nigh on impossible to prove who has it, how much there is, what it's worth, and what to do with it. But the wife there had admitted having a deposit box in the past. We could see in police disclosure that she had mentioned removing jewellery on 2 previous occasions. So looking at the bank statements, we were able to find the details that really nailed her coffin on this point, because you could see several payments for a deposit box to a bank in a location where we thought it might be. And most importantly, on the date when we thought she might be taking that jewellery, there wasn't anything obvious about the location in the bank statements, but there was simply an entry for Asda, and it gave a number. And the numbers, when you have them on bank statements with supermarkets and other sort of bigger shops, will often, if you Google them, tell you it'll be specific to a particular location of that shop. So even though it was quite an ambitious argument to say to the judge, oh, well, we know this is Asda in wherever it was, Reigate or something. The judge took that point because it was specific and clear and had the flavour of spotting something that didn't want to be spotted. Other forged documents, things to set you on the path of suspicion. When you ask for the original copy of a document and it's suddenly not available, it might be in a shed somewhere and people have lost the keys, or actually the other party has the keys and there's no way they can get it. That's already quite suspicious for any important document. In the second case, where again both of husband and wife are lying, the husband cousin had given his house to my client's wife to hold on trust for the party's trust deed was purportedly signed by the wife and the cousin. We had a handwriting expert, and the handwriting expert confirmed that this was the wife's signature. But the agreement looked very strange because there were 2 sections that had very different formatting. And one section looked remarkably similar to an agreement which the husband and the cousin had earlier, later had with the neighbours about a boundary dispute. And those neighbours had made statements that they had prepared that agreement. And they prepared that agreement later than when my client was saying this agreement was signed. And it just, the chances of both the neighbours and them coming up with identical formatting in that specific section of the agreement seemed quite unlikely. And that implausibility was crucial to the judge's decision making. I'm pleased to say I wasn't there for that particular trial where the husband was really didn't do very well. But the reason, in fact, was that the husband, the house was originally bought in the cousin's name because with the husband's money and the wife's from his company, which was supposedly covered up as though it was the cousin's income, but actually wasn't, and just avoided paying a lot of tax. Of course, my client doesn't accept this, but there is a finding. Sham trusts, yet a different case. I had case 3, I'll call it, where the wife had, in addition to the family home, a flat, which she said she was holding on trust for her children from a previous relationship. Her mother had been living in this flat, which was a council flat at the time, and she was struggling to pay the increasing rent, and she asked her daughter for help. She asked her rich ex-husband, who for some reason, several years down the line, was still supporting his ex-wife while she was already divorcing her second husband, and including contributing to their extension on their family home. So it wasn't unusual for him to just gift money to his ex-wife and her new husband. And he agreed to help, transferred £24,000 to her. She transferred it to the conveyancing solicitors. The house was registered in the mother's name, but there was no mortgage, no trust deeds, no mention of any children's interests. 4 years later, it's transferred to the wife, and the mother's paying her a small rent, still no mention of a trust. Around the same time, a declaration of trust document appears, undated, not in the form of a deed, and phrased in such a way that suggests it was created after the purchase had taken place, and it said it was for the benefit of the children. Then the wife takes a mortgage of £82,000 on the flat, £50,000 is invested in some company, the rest is God knows where, changes the name on the share certificates to this family name investment trust. 4 years later, the wife registers this investment trust with a trust registration service. Everything in that sequence seems to be backwards in terms of the order you would expect things to happen if this was a real trust. So luckily it was disregarded. It was considered a sham trust. She in the flat was part of the sharing principle and meeting her needs. But how to spot this sort of thing? With trust, you're looking for the certainty of words, the certainty of subject matter, and certainty of your objects. You've got to have the trust declared and constituted by the settlor, actually settling property and assets on that trust. And the formalities have to be complied with. And I've put down here the 2 obvious ones, the Section 2 of the Law Reform Miscellaneous Provisions Act 1989 and Section 53 of the Law of Property. A bigger issue of trust law that we could spend a whole session talking on its own. Procedurally as well, you would have expected, if it was a real trust, that the children, who were adult children by then, would be invited to be interveners. They were not in this case, but that's part of what you would do if you were trying to spot a sham trust. Now, once you have your suspicion, there are a number of tools available for us to use to do our research. And firstly, the legal tools. Obviously, there's the questionnaires which are exchanged. Part of the reason for doing all your forensic work early is so that you can build your case early on, and you've done for the questionnaire. In the questionnaire, you've included questions that you might then later cover. If they don't get answered, it will be a much more powerful point in cross-examination if you can say, well, we asked you in questionnaire and you either didn't say anything or you said X, but actually now you're saying Y. There are different options of applications you can make for disclosure. It's obviously an application for specific disclosure. If you've asked for particular documents from the other side and they're not providing, then you need to make an application for specific disclosure, so long as you can be specific about what it is you want from the court. If the disclosure you're looking for is not in the hands of the other party, then it's third-party disclosure you're looking at. And specifically in relation to bank statements, the key provision that Lexis AI won't tell you about if you Google this question is Section 7 of the Bankers' Books Evidence Act 1879, which will, if you get that order, it will direct the banks to provide the bank statements directly to you, to the solicitor's firm, of course, not to the lay client. And that means that you will have the real bank statements to compare to whatever you've been provided with before. And remember, when you're asking for these things, to include aliases, so any other names that the parties are known by. There are all sorts of expert reports I'm sure you can get, forensic accountants, handwriting experts. Personally, I'm a little bit skeptical in this. Courts don't really like too much expert evidence. The quality is very variable. You can get all sorts of experts who will tell you all sorts of things. They will charge a lot of money, and it's not often that their evidence will be conclusive. But it may be that if you find the right experts, the good experts, that actually their evidence might be invaluable. And the same sort of thing goes for any kind of investigators. Be very careful that if you do use one, that you ensure it's a reputable one, and they don't get caught putting on their Ring doorbell camera, putting their hand through the letterbox and picking out someone's letters. Other tools to look at to verify information: Companies House, Trust Registration Service, maybe the Charity Commission, but probably less relevant for these sorts of cases. Credit reports can be a good source for addresses. One that very few people know about is the Wayback Machine web archive. It takes a snapshot of all sorts of web pages across time. And so if you have a point where you need to look at what a website said at some time in the past, there is a decent chance, it's not got everything, but there is a decent chance that it might have a snapshot of that page at a date in the past. Now, we found it very useful in case one, where there were two holiday cottages that my client, the husband, was saying were non-matrimonial property, because actually they were owned and managed by him and his sister. And the wife said that actually during the relationship, she was managing them, she was cleaning them and maintaining them, and she was taking orders and bookings from the customers. But we were able to look at the web archive and look back at a page in 2014 for these holiday cottages, which clearly had as contact details the husband and his sister. And that pretty much put that issue to bed, even though in that first hearing, before we proved the forged bank statements, we did pretty badly on everything else. Other small points: observation. There's nothing quite as effective as a judge going out for lunch and coming back saying, after hearing the wife talking about what an old, useless car she's driving, is that you, Miss So-and-so, that I saw getting into this new Mercedes over lunchtime? So that's not to say stalk people, but do keep your eyes open when you are in and around court in case anything interesting happens. And demonstration. One of the very useful things that my instructing solicitor, who may well be on here somewhere at the moment, did in that first case with the forged bank statements, was when the wife was directed by the court over lunchtime to go to the bank and get them to print off her bank statements. My instructing solicitor took my client, and they also went to the same bank to demonstrate that he could print off his own bank statements there, so that there weren't any other issues with it. Of course, what they witnessed was the wife getting to the front of the queue and suddenly, surprisingly, fainting, even though there wasn't later in the medical evidence any reason for her to have done so. How you can use the lies. Obviously, you can add back any undisclosed assets that you find. I've included useful references. I won't go through them because I'm already overrunning. Credibility generally can be harmed. So, for example, once we discovered that all the bank statements were forged, it really rather impacted on the wife's argument when she said she had to live in Warwick, even though she'd been living for 2 years in Doncaster, which, as you can imagine, has rather different house prices. And we were able to persuade the judge at rehearing that actually she didn't need the Warwick level of provision. Section 37 of the Matrimonial Causes Act allows to set aside transactions and make freezing orders if there are particular concerning transactions. Penalties and costs, although I have yet to see a case where the court, because what the court will often do is formulate the award in such a way that it already penalizes that party. So they will often say, well, no, we won't also have a costs order on top of it, but it's always worth trying. You can get the other party reported to HMRC and the benefits office and such like. And you can also get them committed for contempt of court, and the court will take it seriously if you bother. In case 2, the wife did get a suspended sentence, but you do have to remember your old principles of sentencing when you go into court for that, and your robes if you are counsel. I won't go through that, but the references are there for you to look at later. A few limitations to mention. Obviously, we're all aware we can't allege that someone's been lying in court without having the credible evidence. However, if there are inconsistencies in those issues, that is the sort of credible evidence that gives rise for suspicion from which you can do more research. And unless your client's actually telling you one thing and then another thing, then it's very rare that we can actually know that they are lying. You would need to get permission to disclose documents if you're seeking to rely on anything in other family proceedings. You do, if you are planning to challenge someone's credibility or the veracity of a document, need to give notice of that. Nobody does it, and we usually get away with it, but it technically needs to be done. And finally on that, we'll all be aware about the Cengiz and Immerman rules about what happens if your client brings you a bundle of emails and documents they've collected from their other half over the years and says, can we use this to our advantage? Again, I won't go through that because that's a topic of its own, but some of the points are there for you to see. And of course, just as a final point before I round off, sometimes it is your client that is lying. The indicators might be things like you ask them a question and they say, well, shall we say X? And in which case you say, well, no, you need to tell me what we're saying. You might have ask for a third party to send you an email and you get it immediately when talking to your client. You might find that their story adds up too well. Don't judge them. We're not in their shoes, but do advise them robustly and sensitively, and let them know, give them advice on what the facts as they say, and then give them advice of saying that you are concerned that the court might not believe you. You can blame the court for being unfair, but say if that happens, this might be the outcome. It might help them that way to be a little bit more honest, to give you more information. But ultimately, it is their own fault if they are lying. And generally, in my experience, the court and justice will catch up with them one way or another. So don't stress. So in summary, analyze the bank statements or instruct your friendly counsel to do so for you. Start a spreadsheet of anything suspicious early. Apply to the court for the evidence you need to back up the suspicions. Don't do anything that will make you look bad in the eyes of the court, or your client, obviously. And make the issues clear to the court, explaining the motive so that they are more likely to believe you. Now, I'm sorry it was quite a rattle through all the different issues. I hope that you found that talk useful and that you find the slides useful as well.